All right, everyone. I think we're at 2 o'clock, and we have a lot to cover today, and I want to be respectful of your time. So let me introduce myself. My name is Brian Perlberg. I serve as Executive Director and Senior Counsel for Consensus Docs. I'm speaking to you today from the Washington, D.C. area. It's a hot summer day. Thank you for attending today's webinar, Using Master Subcontracts, How to Become More Efficient in Negotiating Your Subcontracts. We have a great audience today with 300 registrants for today's webinar, and we have a great topic and speakers to match to merit such a large audience. On today's webinar, we will be covering when and how to use master subcontract agreements, including how to organize the terms and conditions in the master agreement, as well as separating out the project specifics in a project work order. Today, we're going to give you an overview of two brand new standard construction documents recently published by Consensus Docs, the new Consensus Docs 755 Master Subcontract and the 756 Standard Project Work Order. And we're going to talk to you about how this, we're also going to cover how this is different than other standard documents within our catalog and to a certain extent how this is a different approach than what you're used to seeing. So with that, let me introduce our speakers. First, I will take the opportunity to introduce Kevin Peartree. Kevin is a partner in Ernstrom & Drusty in Rochester, New York. Kevin's been involved in Consensus Docs from the very beginning, before Consensus Docs really existed as a known entity to the public world. He was outside counsel to the AGC Contract Documents Forum, and he was a principal participant in the development of Consensus Docs, which were originally published in 2007. Kevin's remained active in both AGC of New York and AGC of America. He is an active member of the AGC Contract Documents Forum, and as well as several working groups for Consensus Docs as a volunteer. So much so that he is the lead author of something that's on my bookshelf, the Consensus Docs Contract Handbook, which is published by Walters Kluwer. He also served, I should highlight, he served as the vice chair for the working group that created the two standard documents that we will touch upon today. Next, let me introduce Joe McAllister. Joe is General Counsel of Hughes Construction based in Utah. Hughes Construction is a multifaceted general contractor that specializes in construction management, as well as having a very good expertise on design-build projects with tilt-up concrete. Joe serves as the general counsel for them, and he served as chair for the working group that led to the master subcontract agreement and work order. And really, he's the one who came to me with, we're going to talk a little bit about this, but came with me to me with the idea of, hey, I'm seeing this all the time. We really need to have a standard document to address this. So let me take some administrative matters up top first. We do encourage you to ask questions, and we will hopefully answer them. The way we do that is there should be a box that you have that you can submit questions through where it says questions. You should be able to submit something as an attendee for today's webinar. I'm going to try to monitor those and potentially take them as we go, but we definitely will have time with the formal Q&A at the end of our 60-minute webinar, and hopefully we'll end before then so we can take those, but we're willing to go a little bit longer today so we can get to all of your questions for sure. So with that, let's begin. Oh, and I should actually handle the number one question that we do get all the time, and the answer is yes. And the question is, will I get a copy of the recording? And we will be sending you out an email. The email will come out under my name, Brian Perlberg. You should have already received an email from Consensus Docs with the sample of the 755, the sample of the 756, and a PDF of today's PowerPoint presentation. So let us begin, and I'm going to advance the slides. Okay, so a little background here. This is a webinar being sponsored by Consensus Docs. I have the honor and privilege of serving as Executive Director of Consensus Docs. And just to give you a background of where the Master Subcontract Agreement fits within other documents, I'll give you a quick background of the catalog that Consensus Docs offers. we offer things in project delivery methods. So the 200 series is design, bid, build. Our primary agreement is the 200 that has the terms and conditions. The 240 is the document that has an owner design professional agreement. Those general conditions are something that sets the stage for many of our other documents as a starting point. The 300 series is IPD, 400 is design build, 500 is construction management at risk, 700 is where we house our subcontracts, and that is why we have numbered the documents that we're going to go over today and that topic area in the 700 series. Although I will add in the design build, we have subcontracts that are oriented towards design build. 800 is CM agency, and our 900 series is for public-private partnerships, or P3s. Look for early September a release of our first prime agreement in the P3 area. Excuse me. All right, so consensus docs. What is consensus docs? I would suspect most of you know what consensus docs is, but briefly, it's an organization, a coalition effort of 40 organizations. The mission of the coalition is to develop best practices and publish standard construction contracts and help the industry understand them by doing educational events like today. One of the things that differentiates consensus docs from other standard documents is owner input. And I just circled the 5 owner organizations, and 3 of them are the 3 largest owner organizations that have been with consensus docs from the onset. That's now 11 years, and that's NAFSA, CURT, and COA. And there's a thought here that the owners, their involvement, a very important part of the contractual, really, life cycle. And if you start out with a fair contract at the prime level, that can flow better to the subcontract level. And we do have, obviously, a big coalition of general contractor organizations like AGC, ABC, NUCA, subcontractor organizations, but also design professional organizations and groups in the surety field as well. And the point is, if we can get everybody at the table at the national level, have a better foundation to build, that should flow to you and your project. And obviously, the best way to use these documents is off the shelf, holistically, from start to finish. But another technique is to pick and choose certain provisions from them as a way to transition to better contract provisions. Consensus docs has been around for 11 years now. The most important thing that I like to emphasize now that I couldn't talk about when we launched 11 years ago, when I was basically doing a roadshow and after we made the cover of ENR, was now we have a track record. We've been around. We're not a flash in the pan. We have, in the last 5 years, we've had 160,000 or more contract documents finalized through our platform system, which is Microsoft Word compatible. And to date, we have not had one, meaning 0, cases that have been litigated and then reported in a court judicial decision. That doesn't mean that if you use consensus docs, you're never going to have a claim, but I think it's an indication that because you're not seeing these litigated cases that are reported in judicial opinions, that you have a much better chance when you start out with a fairer contract, and that's what all the studies say. We've reached over 3,000 subscribers, and with people like you listening today and suggesting and maybe even conditioning their bids based upon the use of fairer contracts, we anticipate that usage to grow even more. So with that, I mentioned earlier that Joe really did come to us with the idea of creating a standard master contract, and I wanted to hand it over to Joe for him to take over and talk a little bit about how we got here today and some of the benefits that he sees.
Well, as an in-house counsel for a general contractor, one of the things that I was surprised about after coming in-house is the amount of work that happens after the award of a contract from an owner. Everybody's aware of the bid process and the negotiation of the prime contract, but that really is just the start of the work for project managers, project executives, and subcontractors. And what we were seeing is we were spending so much time and effort reinventing the wheel. We had this, 37-page subcontract agreement that we've been sending to the same subs, in some cases for 25 years. And they would review it and they would make changes, and sometimes it just depended on the day, which project manager got it, how good of a mood they were in, what changes they decided they wanted to make. And they would send that back, and that entire agreement then had to be reviewed, the entire 37 pages every time, and you had to go through it with a fine-tooth comb to find everything that was different. And then you'd have to have your phone calls back and forth, and everybody would have to negotiate on every individual project, the entire contract, over and over again. Well, that just takes too much time. When you're talking dozens of subcontractors on each individual project, the project managers were just spending so much time just passing contracts back and forth and coming to me and asking me to review it again and again and again. And so we had noticed in the industry a large move to master subcontracts, where this allows you to bifurcate the contract documents into two sections. One being primarily the relationship between the subcontractor and the general contractor. Those terms and conditions that are going to be applicable on almost every instance of every project. And then there's the project specific stuff. And if we can separate those and negotiate the general terms and conditions one time, and do it with the assistance of legal counsel and the project executives and everybody on board, and everybody agrees what is fair and what is reasonable, and then we solidify that. We finalize it, and we don't have to go back over and over and over again with different project managers, different project executives on both sides of the contractor-subcontractor relationship. We save time, we save hassle, and then we know, without a doubt, we don't have to look at the contract every time we have a project and say, what did we agree to on this job? What did this sub agree to on this job? We know what they agreed to, and they know what they agreed to, and it allows for us to have a uniform contract management process across all of our projects with that individual subcontractor. And by doing that and doing it once, then we allow on a project basis that we can just focus on the work, the project work orders, which are project specific. The project executives and project managers can primarily negotiate and finalize with legal insight, if they need it, the details of how that individual project will be worked out. Schedule, cost, scope, all those things that frankly they are far more qualified to review than an attorney. And we have found that by doing that, we save time, we save effort, and we avoid conflicts where individuals, subcontractors, have a different opinion of what their duties and responsibilities are from one project to the next. And it has been a huge benefit to us.
So let me ask you, do you ever have a concern with someone about empowering folks who are better qualified to negotiate the project specific? As a general counsel for a construction firm, are you ever concerned that someone's going to go off the rails and try to change the master services agreement with the project work order?
Well, I think that's always got to be a concern, but I'll tell you, back when I was a litigator at a law firm, I had a very large client who does $750 million worth of work just in this state and more in other states. And I asked them who reviewed their contract, and they told me their accountant. And that is pretty common. The vast majority of contractors out there don't have an in-house counsel to review every single subcontract agreement. The reality is a lot of times it is done on the project executive or project manager level. And so those folks, they hopefully are experienced, they are familiar with their contract terms, and what we try to do is we try to give good training to our team to know the difference between project-specific scope of work, means and methods type of things, and terms and conditions. And when they know that, they're pretty good about coming to me for terms and conditions advice and when things get changed on the terms and conditions, and then they handle their business when it's a means and methods. And so we haven't had any major issues on that front because it's not hard to explain to our project folks that there are some traps out there that they need to be wary of, and they're pretty good about bringing that up when they have a concern.
But if I can jump in as well from my perspective as an outside counsel working with construction companies, a lot of them don't have the benefit of having someone like Joe in that general counsel position sort of dictating procedures, and too often you see problems where the business people maybe who are out chasing the work are signing the agreements, negotiating the agreements more critically, and altering the terms of what might otherwise be a standard agreement that the company has developed. So when issues do arise, you don't necessarily know what you're dealing with, or at least the expectations that you have of what the company was doing in terms of its approach to risk may have been altered by somebody out in the field or a business person chasing the job. So just to add a few more thoughts here, I mean, certainly one of the benefits of using consensus docs is that it can cut down on your transactional costs in terms of negotiating agreements. Having a master agreement such as this can only do that even more. I think the other benefit of having a master agreement like this in place is that I think as Joe has already articulated, it solidifies the procedures among your own company and solidifies your people's understandings and expectations when dealing with, in this case, a subcontract agreement. So it has the positive effect, I think, of reinforcing the culture of a company and its approach to risk management. So we are seeing more and more clients who want to move towards having master subcontract agreements in place when it's appropriate. And I think later on in this talk, we'll get into some of the considerations of whether you should be using a master, when it's appropriate to do so.
And those are great points, Brian. And I would just like to emphasize that through Kevin's expertise in contract drafting, the Consensus Docs 756 project work order is structured in a way that it functionally will avoid a lot of those potential problems, because there isn't 10 or 12 pages of additional verbiage where you might find folks wanting to cross things out, add things in. The dirty work is done in the master subcontract agreement, and the project work order is 2 simple pages. And because it is exhibit driven, those things there's not really a functional need or motivation to do a lot of changing of the substance of the actual project work order language to create conflicts with the master subcontract agreement. So in that sense, the way that it is structured really is a big benefit and improvement over a lot of the project work order notice to proceed documents that I've seen in the past.
Right.
Very good. And before we move on, Joe, I just want to make sure, because I had to monitor some of the questions coming in. Do you feel like we hit the point about I think it's really important about the insurance coverage uncertainty, and that by taking this approach, that folks who are mobilized on the site have the insurance requirement?
As most of the construction folks out there will know, one problem after notifying a subcontractor that they've been awarded the project and then sending them a copy of the 37, 40, however many page subcontract agreement that you have with them is you never know what the turnaround time on that is going to be. And then when you get it back and you need to bring it to legal counsel or seek advice from your legal professionals, that just takes time. And with the fast track nature of construction these days, every project seems to be fast tracked. There's not a lot of time, and so you end up in that situation where project managers they want to get those subcontractors out on the job site, and those subcontractors are feeling the pressure, and so you'll have people mobilizing onto a job site before the contract has been fully negotiated and signed. And that creates a problem for a number of reasons, but that can be avoided with the use of a master subcontract agreement, and you can take advantage of what almost all subcontractors have in their insurance program, which is an additional insured endorsement that it provides automatic status when required in a construction agreement. And so by having this written master agreement already signed and agreed to, and only needing to define the scope of work in a project work order, you are already, as the general contractor, an additional insured under the terms of that endorsement. And so you don't have to worry about a subcontractor being out on site and you not being a named insured, or an additional insured under their insurance, and not being sure if you've got the coverage. And so you avoid some of those disputes, some of those concerns, and you're able to get subcontractors out onto the job site faster when you understand really what all we need to do is we need to finalize the scope and the price and those kind of things. So it provides a benefit to deal with the reality of fast track construction and mobilizing subcontractors that usually needs to happen a little faster than contract negotiations and attorneys' work.
If I were going to add anything to that, it would be having a master subcontract agreement program in place helps to mitigate against the situation that I unfortunately see too often, which is a situation where an agreement, a subcontract agreement, never gets executed, and you go way down the line and you get people asking you to review contracts when the work is 80% done, or they come to you with issues and the subcontract agreement was never signed off on or executed. Having this type of program in place helps to make that a rarer event.
It's true, and to implement this across our entire company or any company really is nothing more than just sending out a letter that explains we're going to negotiate a master contract, and then we will send you project work orders, and it's very simple. And the next time you award a contract to a subcontractor, you just send the letter and a copy of the master contract instead of your standard subcontract agreement. And you go from there, and you eventually cover all of your subcontractors, and at least everybody that you've awarded a project to, you're going to have at least your general terms and conditions and an understanding of how your relationship's going to be managed.
Well, there's a great point. Oh,
go ahead, Brian.
I was just going to say that's a really great point, and I would say that we didn't intend to address that issue, but it seems like that's a really good benefit of the master subcontract approach about this coverage for insurance by taking this approach. That might be, it turns out, one of the biggest reasons why people move to a master agreement type of approach. But yes, with that, I was going to ask Kevin, you've been at the beginning of consensus docs and helping us draft things like our consensus doc 750 long form subcontract. Why don't you talk a little bit about how the 755 master subcontract agreement kind of follows from that philosophy? Okay.
So Brian has already highlighted the nature of the consensus docs group, the Association of Associations. And I think that sort of lies at the heart of the philosophy of the consensus docs in the 750, from which the 755 emerges. Just to go back in time for a little bit here, when we got together to draft the consensus docs originally in 2007, we brought together a variety of representatives from industry associations. The subcontract form was a particularly challenging one to put together and to reach consensus on, because there are elements of the subcontract agreement that contractors and subcontractors can have very different feelings on. But when people came into the room, the philosophical idea was, all right, you're taking off your hat as the contractor or as the subcontractor or owner or designer or whatever the case might be, and the guiding principle here is going to be what is in the best interest of the project, with the idea that if we serve the best interest of the project, we should also, in the end, be serving the best interest of each of the individual parties. So that's sort of the overarching philosophy behind the consensus docs, as well as the consensus doc 750, from which this master subcontract agreement emerges. So we think we have achieved, by the input of contractors and subcontractors alike and their endorsement of the agreement, a fair and balanced approach that uses that hallmark, the guiding principle of what is in the best interest of the project. The document as drafted, the 750 and the 755 that follows, was drafted to be integrated with the rest of the consensus docs family, if you will. So the terminology, the risk management approach to it, the risk allocation approach is consistent throughout the documents. So you will find that this document, the 750, works not only across the consensus docs family, but we also drafted it keeping in mind that there are times when people will want to use this document even though perhaps the primary document might be an AIA document, for example. And so it was drafted to be, as much as possible, compatible with other standard documents and manuscripted forms. The 755, just like the 750, is integrated with the rest of the family of documents. In addition to the philosophy that I talked about in terms of the best interest of the project, you have that statement at the beginning of the document that the parties agree to proceed on the basis of mutual trust, good faith, and fair dealing. And just to give you maybe a couple examples, not to get deep into the weeds of the philosophy of the 750 and what I think exemplifies its balance and fairness, I'd ask you to take a look at the indemnification provisions. In 755, it's 9.1.1, and also look at its approach to how we tried to deal with the issue of additional insured coverage, which is, as you might expect, a hot topic between subcontractors and contractors. And then finally, you might take a look at the dispute mitigation and resolution procedures that are employed in this document, all of which I think go to underscore the balanced approach that we tried to achieve. And one other thing I might throw in there, I'm going to ask Brian to address the pay if paid topic that you see up there on the slide. Well, Brian, why don't you go ahead and address that now?
Well, I would just say that that's, of course, a hot button issue, and when we were preparing for this webinar, I thought, well, maybe we should just proactively address that a bit. And as a standard document, like the 750 and the 751 short form, the document is pay when paid, and that is the standard which we have come to agreement and consensus. I know that there's different views on that type of provision. I know a lot of people feel like there's a pay if paid provision, and that's a tough one, right? And so the bottom line is this is the best practice standard that we put in and publish in our document. So people feel differently. This is one of the few issues where at least one organization involved in consensus docs has on their website alternative language, not saying that it's a better best practice, but they have, it's pretty easy language to implement pay if paid if that's what their determination is. But that is not what's published in the coalition effort. And that's the one question I always get, right? Like, hey, is this pay when paid and pay if paid? And you have to look at your state law on that issue. And that topic's probably a whole nother webinar, and it's a hot button issue. But I did want to address that. And one quick shout out I wanted to give to Joe. The other big question I get in addition to pay when paid is, can you make these contracts shorter? And now I have a good answer that everybody always wants a one-page or a two-page agreement. And now thanks to this purchase work order that we've published, we actually I can actually say that we've done that. And so you can focus on on that. So that's really my mantra a lot of times, as to how can we make things more clear and more concise, and I feel like we've hit a new landmark with this document.
And if I were going to add one more,
yeah.
if I were going to add one more thing about the philosophy, one of the things that we've tried to do through these documents is use them to drive discussions between members of the project team, if you will. So to drive discussions between contractors and subcontractors, knowing that they themselves are going to very often and have the ability with these documents to formulate, craft, revise the language in a way that suits their particular needs. So some of these provisions are in there because they need to be there, but also with the idea that this will get a discussion going between the parties. The other thing that I often tell people as a practitioner is that I use these documents often when negotiating other contracts, because, as you well know, sometimes you come across some very challenging provisions or onerous provisions, and it's a benefit to be able to turn to a document like this and say, well, here's an indemnification provision, for example, that I think is balanced, and, oh, by the way, it's been endorsed by subcontractor groups, contractor groups, owner groups, etc. So it's a way of helping to create, I think, a better culture in construction overall, having a document such as this. So maybe from that, I should transition now to the next piece. I wanted to get into some of the particular things that we had to look at and change in terms of the 750. So if you had to make it into the 755 master agreement. So if you were to take a look at the two and compare them side by side, you'd notice some of these changes. First off, in this master subcontract, the 755, it starts right off in Article 2.1 with sort of an overarching philosophical statement. Maybe it's more than philosophical, it's very practical as well, about what the impact and the import of this MSA is. So it's intended to govern all projects for which the constructor engages the subcontractor. It does not create an obligation, though, for the contractor to use the sub, or for the sub to accept future work, but it establishes the terms and conditions for that relationship going forward. And then from that, as each specific project arises, there will be a project work order, which is the 756 form, that the parties will modify and execute, or execute something that is equivalent to it. And that document itself will incorporate the MSA by reference, and also incorporate the necessary terms of any prime agreement, as well as any other critical terms for the creation of the project-specific agreement. So we start off with that important principle that establishes the parties' understanding of how exactly this document is intended to be used. And then, if you look at 2.2 of the 755, it references master documents. I know Joe's going to get into this in more specificity later, but the idea here, generally speaking, is that there are often standard requirements that a contractor has, maybe standard forms, standard procedures, that they include with any standalone subcontract that would also be necessary to include as part of establishing a master subcontract relationship. And so those would be listed out, referenced in 2.2, and included most likely as an exhibit to this agreement. Then if you look at the definition of subcontract documents, the only significant difference here, obviously, is that unlike in the 750, which is a standalone, now we need to account for the fact that there is going to be a project work order, which is itself a critical subcontract document. So the subcontract documents are going to include not only the MSA and its exhibits, but then also the project work order, its particular exhibits, the prime agreement, and on down, all of the typical provisions, elements of a definition of subcontract documents that you see in the 750, for example, carried over here. Next, let me go to the next slide here. The subcontract work. Now, for example, the 750 has a provision under 2.5 that gives you a definition of the subcontract work, and then in a later section here, I don't have it right in front of me, but by exhibit defines the scope of work for the subcontract. Well, obviously in a master subcontract situation, you're not going to know what the scope of work is yet. So the 755 approach has similar language defining the subcontract work, but it accounts for the fact that the actual scope of work is ultimately going to be defined in the project work order. So there's a reference to the project work order. There's no specific scope of work document that comes with the master per se. It is ultimately Exhibit A in the project work order, which we'll get to in just a little bit here. Under 2.6, you have conflicts. How do we deal with that? Well, now you have to factor in the existence of the project work order. So generally speaking, as a general default proposition, the MSA is going to govern over all of the other subcontract documents, while the project work order, presumably with greater specificity about project-specific requirements, will govern over the MSA. Now, it's always important to take a look at that and make sure that your particular prime agreement, for example, doesn't create any provisions that might be at odds with what you include with your project work order. We have a mantra in my office that the founding partner has gone by for years, and we continue to go by. It's referred to as RTFC, which means read the freaking contract, and it underscores the importance of knowing, especially when you're talking about a subcontract, what is in the prime contract that needs to be and is flowed down into the subcontract. You'll also see under 2.7, it should be 2.7.8, that we've included in here a definition of the prime agreement. It's a pretty straightforward definition, but it's something that wasn't part of the 750. Obviously, it's the agreement between the owner and the constructor for the project that's applicable to the subcontract work, which is ultimately defined in the project work order. And then recognizing that it didn't make sense to define the representatives of the respective parties in the master necessarily, though you presumably could do that for maybe somebody at a higher executive level. Ultimately, the sub's representative and the constructor's representative will be designated in the project work order itself. And we'll touch upon that in a little more detail in just a second here. So why don't we move on to the next slide, subcontract amount. So if you were looking at a 750 and comparing it to a 755, one of the first things you would notice is that Article 6 is gone. The Article 6 dealing with subcontract amount is gone for obvious reasons, and that is because that is a topic that will need to be addressed on a project-by-project basis, and therefore in the project work order. We also had to do the same thing essentially with the timing for payment applications. That is the decision we made. So that is something that will ultimately need to be addressed in the project work order. It is not specifically addressed in the 755 as a default, though certainly, given that parties can modify these documents to their particular purposes, if you're more comfortable having a defined time for the submission of subcontractor payment applications, you can define that in the master if you so choose. Another difference that you will find between the two is how we treat the additional general liability coverage question in the 750 as part of our attempt to reach consensus. We took a check-the-box approach, providing the options of checking a box for additional insured coverage, or as an alternative, where did it go here? Brian, I'm drawing a blank on the alternative, but...
oh, you mean like NOSIP or CSIP?
Yes, exactly. Exactly. So there was, but the bottom line here is that that alternative approach that was spelled out In the 755, the election was made, and it's an OCP policy that's referenced in the 750, Owners and Constructors Protective Insurance Policy. The election was made that this is something that the parties will typically address on a project-by-project basis, and therefore we will let the parties address that through the project work order. A few more changes that needed to be made to transform the 750 into the 755. You will see some slightly different language in the termination sections, and that is because obviously there may be situations where, because of a default, a contractor needs to terminate a subcontractor, but perhaps only with respect to a particular project work order, if it happens to be the case that that sub is also working and working just fine on other projects under other separate project work orders under the master. So you'll see, if you look in those provisions, the ability of, in the event of a subcontractor default, the ability of the constructor to terminate, if appropriate, the master altogether or just the project work order. That also carries over into the treatment of contingent assignment for the situation where an owner terminates the contractor and they have in their contract a contingent assignment of subcontract provisions. Obviously, in that case, you're not contingently assigning the entire master subcontract agreement relationship. It is, strictly speaking, just what flows from the project work order. And then in the order of precedence, the language that we incorporated into the 755, you'll see that we had to incorporate a place for the project work order. So we start with change orders that arise, project-specific change orders governing, and then the project work order, and then the MSA, and on down the line. So that just gives you a sense of some of the things we had to change. In other respects, you will see that this follows and stays true to the 750. So let me go very quickly to the next slide, because that tees up Joe's discussion. And if you take a look at the 756 form that we have developed to go with this, the project work order, it is an exhibit-driven document, meaning the parties, it gives a lot of flexibility to the parties to develop what they need to suit their own specific requirements. And so scope of work, schedule, subcontract amount, insurance requirements are all going to be treated most likely through an exhibit that the parties have developed. There's also elements of the 756 that will address the project-specific retainage requirements, bonding requirements, and party representatives. But I want to give Joe time to get into some of the nitty-gritty on that, so let me hand it back to him.
Okay, so as you heard earlier, the master subcontract agreement only needs to be agreed to one time. And this generally is going to cover the agreement between the contractor and the subcontractor, exclusive of any consideration of an individual project or an individual owner. And so what you want to make sure is that when you're creating this master subcontract agreement, whether you're filling out this 755 or whether you're using the terms and conditions from the 755 to structure your own master subcontract agreements, is that it needs to reflect your standard processes and procedures. This is your master subcontract agreement. When you're both as the general contractor and as a subcontractor, this is your opportunity to make sure that your standard practices and procedures get put in there. And similar to the RTFC contract rule, you also need to make sure that you are managing according to the contract, that your project managers have read the contract and that they are managing the project in accordance with the contract. It does no good to have a written contract and then to just completely disregard it and manage the contract in a totally different way. So read the contract and then follow the contract. And the best way to do that is to at the beginning, to make sure that you're incorporating your processes into this subcontract. So for example, at the beginning of the the consensus doc 755, and I'm just going to start on the first page and go over a few important things to note. In the table of contents, you can see what these different articles cover. And one thing that I see often in these contract negotiations is someone will start reading through the contract, and in Article 3, they will start writing in modifications to their responsibilities that have to do with insurance or dispute mitigation, or what will happen if they get terminated, or what their timeline for correcting a notice of default is. But you need to make sure that when you're negotiating these contracts, that you contain those provisions within the appropriate article. Don't negotiate language inside Article 3, the subcontractor's responsibilities, that should be contained in Article 8 for indemnity, insurance, and bonds. If changes are made in those sections and you're amenable to them, or you're willing to take some modification of those changes, make sure that it gets put in the correct section. That way, when your people go back and read the contract, they know where to look for all of the requirements for managing it. You don't want to have someone go read the indemnity provision and then find out that there's something else involving indemnity under Article 3. So just pay attention to the table of contents, the table of articles as it's called here. And then I would just point out on your constructor and your subcontractor name areas, and this is a pet peeve of attorneys everywhere, but please use your company and your subcontractor's company's full legal names. It's really important that when you're filling these contracts out, that you enter your actual full legal names in there. And then when you're entering all these in, when you're searching for your master subcontracts and those things, it's always just there. It's just easier. And then all the things related to contractor licenses is for your own individual state compliance. But I'll point out here that on page 2, there's master documents, and that's section 2.2. Now, this master documents section is your opportunity to incorporate into your master subcontract agreement all of those documents that you use to manage your subcontractors. So there's one box here, but you can list as many as you want. Now, I would suggest that in order to keep these distinct and separate from the exhibits that are listed in the project work order that we're going to go over, those are listed as Exhibit A, Exhibit B, Exhibit C, is that you use the terms Attachment 1, Attachment 2, Attachment 3. You could also say Exhibit 1, Exhibit 2, Exhibit 3, but some way to differentiate between those types of documents. And the documents that should be incorporated here by reference and by just straight attachment is my suggestion. It's easier that way, so that everybody has a copy. For example, would be things like your safety requirements, your payment application forms, your insurance compliance statements. If you have a hazard communication statement, if you've got joint check agreements, waiver forms, billing forms, whatever those are, the things that you're going to use to manage your subcontractors, not your individual project, but to manage your subcontractors that are generally applicable no matter which project you're on and which owner you're working for. Attach those here. It's easier. And then you can always just refer back when, if somebody doesn't submit a particular form. It's easy to just go back to the master subcontract agreement and say, here's the form. It was required in the master subcontract agreement. Please use the appropriate form so that we're not getting, 15 different versions of a particular form from your subcontractors. Other than that, the remainder of the master subcontract agreement is really language. There's not things that you need to fill out, but what you do need to do is make sure that you familiarize yourself with the language. And if there are either state market or company-specific procedures or changes that you want to see in here, you can go in there and edit that. That's one of the beauties of this document, is it isn't a Word document, and you can go in, edit it, re-upload it, make it final. It is editable, but so go in and make those changes. Make sure that you familiarize yourself with those obligations. Now, most of this everybody's going to be concerned with, does this cover me? If I'm a general contractor, does this cover me based on what my requirements are to the owner or to an individual project? And the answer to that is yes. The way that this has been structured and the language that has been used is that it makes it functional but flexible, so that the obligations of an individual project are undertaken by a subcontractor. Now, each individual state is going to have its own individual rules about how provisions flow down, and you'll need to be familiar with those in the market that you're working in. But that's just the reality of every contract. But this does have a good mix, a good balance of how to bring in the obligations that the general contractor has to the owner and the obligations that the subcontractor is going to have to the general contractor as a result of that. Everybody always wants to know, what are the most important provisions in the contract? Which ones do I need to focus on the most? And I'll tell you, the reality is, vast majority of subcontractors and general contractors, they get a contract, they open it up to the part where it says how much they're going to get paid, and if that looks right, the contract's okay. But I would say that for each individual subcontractor and for each individual contractor, the real focus for you should be this Consensus Doc 756, the standard project work order. Because in this, you're going to be defining what is the scope of work, the payment, the procedure for progress, drawings, specifications, all of that. And so I'll just call your attention, if Brian, you could just advance to the 756 slide, you'll see that this is a simple 2-page document. It is exhibit driven in that you will use the actual project documents or a template or a format that you can create on your own to meet your own needs in order to define what the subcontract work is, what the drawings, specifications, project conditions, all these things are things that already exist or that are known to your project team, or that should be known to your project team. One important thing though at the beginning here is, just as you're going to fill out the constructor and the subcontractor, is that in the first section 1.1, you're going to put the date of this project work order in the first box. But then in that second box, you're always going to want to refer back to the master subcontract agreement. And that is how you'll reference that. You can do that a number of ways. You can use Sage 300 to incorporate that through a merge document. You can keep a master spreadsheet that just shows every subcontractor and the date that they signed their master subcontract agreement. But that's not hard to do. You can all figure out how you do that, but you'll need to reference that. And then on your scope of work in your list of exhibits, one thing that I would encourage most of you to do is to use the project documents themselves. When you're defining scopes of work, use specification sections. Go to the project manual and use the sections from the project manual. It helps you avoid scope gaps, and it helps to define so that the project documents define the scope of work, because ultimately the owner's expectation is going to be they're going to get what's in the project documents. So use those project documents, refer back to those.
Joe, let me interject for a question, if I may interrupt your flow for a sec. Is when you're talking about the date of the agreement, one of the questions we've gotten a couple of times is, what is standard for how long the MSA lasts? And is it annual? Is there an expiration?
Yeah, so the standard is that it's open-ended. there are a number of, a lot of times, service agreements and some subcontractor agreements that will be an automatic annual renewal. But the one thing you want to be careful of if you're going to do an automatic annual renewal is that one party you would have to give notice that you did not want to renew, but you would need that master subcontractor agreement to continue on past the completion of any project work orders that were currently in place. So the best thing to do is to have it an open-ended agreement. If you need to come back later and renegotiate these things, the parties can notify each other, in that manner. But an open-ended agreement, because the fact is, most of the time on especially commercial projects, from the date of award to the date of completion on almost every subcontract is going to be longer than a calendar year, and so. You really don't want to create any situation in which somebody has to, affirmatively go out and renew their master subcontract agreement, because it will inevitably be forgotten. But an open-ended agreement is pretty standard for a master subcontract agreement.
Yeah, I agree, and that's certainly been my experience working with non-standard master subcontracts agreements such as this. That's why we took the approach we did in drafting it, because we thought that it reflected the realities of of construction and how these documents are used out in the industry. If I was going to throw in one more thing, because I know we have maybe just a few minutes left, though we'll certainly have time for questions. Is another thing that I harp on with subcontractors and contractors alike, because it happens, the situation comes up all too often, and it's sort of a corollary to RTFC, and I would call this corollary GTFC, which is get the freaking contract, because all too often, working with subcontractors, for example, they will have an issue come up, and they'll want to know what the answer is, and they'll give you their subcontract, and I'll say, okay, what does the prime contract say? Because that's incorporated by reference, and they'll say, well, we don't have that. And now that we think we might have an issue, we don't necessarily want to go asking for it and potentially raise a red flag to the contractor that we're thinking about such things. So for the subcontractors, I say, get the freaking contract, and frankly, for contractors, you want your subs to be fully knowledgeable and educated about what their requirements are. So I say, give the freaking contract to them as well. So I wanted to harp on that before we ran out of time.
Yeah, I absolutely agree, and I'll just add that for the most part, it's good practice, and most good projects and good architects and good general contractors are going to include a copy of the prime contract in the project manual. You should look for it there. If you don't have it, request it. But on the side of a general contractor, if you really do want your contract provisions to flow down, if it is that important, you should be taking steps to make sure that the subcontractors are aware of them and that you note them. If there are flow down provisions that you want to be included, put them in the project work order. If there are specific provisions that you want them to note, put that in the project work order, and call it to their attention. You don't want to play a game of hide the football or gotcha with a subcontractor, because it just creates disputes later. Which is why I think that the structure of using the actual project documents, the references to the drawings and specifications, the schedules, is the way to go. It is the way to avoid conflicts later.
And Brian, if I could jump in, I know we're coming up on the 1 hour mark, though we're available to continue on and address some questions. And what I wanted to address is the vetting process, if you will. I mean, when you were thinking about using a master subcontract agreement, it's certainly been my experience with clients, and I also think it's a good practice to vet those whom you would sort of welcome into the use of a master subcontract agreement. Certainly you want to vet all of your subcontractors as best you can, but for those that you're going to open up to this type of master relationship, I think it's important to do a proper vetting of who they are, which means you got to look at their past and current performance. You want to look at their safety record. You want to look and see the extent to which they are involved in claims and litigation. Examine their bonding and insurance, their financial well-being generally, their staffing levels, and all these kinds of things. And you may want to develop and utilize some sort of subcontractor qualification forms. Brian, I don't know if do we have one of those at this point in the Consensus Docs family? A statement of qualifications? We do.
We have several different types of pre-quals. We have one for architects and engineers. We have two different versions of that. We have one for generals. We have one for subs. And actually, we've worked with a lot of technology companies in the construction field to allow them to upload that to their system. So when you update your qualifications, that automatically updates to all the people who are in their system across multiple projects.
Right, but it's certainly a good practice to employ all the time, but in particular when you're looking at developing that master subcontract relationship. So I wanted to add that before we perhaps ran out of time.
Yeah, I would echo that subcontractor pre-qualification is becoming probably the most important issue in the general contractor world, and incorporating a subcontractor pre-qualification and master subcontract agreement negotiation up front is going to be critical, especially for those who work in multiple markets and end up with subcontractors that they haven't known for, from projects in the past. Well,
I think as you guys alluded to, we are at the top of the hour. I wanted to get to we've done a couple of questions throughout, which is really the best way of doing it. I wanted to ask you, for people in the audience, if you have additional questions, you've been doing a great job of putting them in the Q&A, and I've been monitoring those, and we'll take some now. I feel like we somewhat hit this question, but I kind of want to come back to it again. Is sort of twofold. I'm kind of combining maybe a couple questions. Is how do you handle if there's a conflict? I think Kevin basically handled it a little bit, but how do we handle conflicts between the master and the project work order? And isn't there a little bit of an interplay between the incorporation, since the tricky part of this is that it covers multiple prime agreements with multiple owners, multiple projects who have their different prime agreements? How do you handle when there's a conflict between what's in the MSA and the project work order?
You mean, Brian, in a situation where you don't want necessarily the default order of precedence that we have established? I mean, I think what it underscores is the importance of reading the prime contract and understanding what needs to be flowed down and where there might be conflicts. We drafted it the way we did because more often than not, you're going to get the project work order and the scope of work are going to be so specific to that particular area of work that it's perhaps unlikely for there to be a direct conflict between a requirement of the project work order and a requirement of the prime contract that's made part of the, that's included within the definition of subcontract documents. But certainly, while we're trying to make things easier, and I think we are, through standard forms and through the use of a master agreement such as this, it doesn't take away the need to examine that prime contract for just those kinds of things and then specifically address those kinds of conflicts in the project work order if that's what you need to do. So that's how I would answer that.
Yeah, and I would agree. I think the language of the master subcontract agreement controls the relationship, except for when there is a more specific provision of the project work order, or to the extent that the prime agreement is applicable to that subcontract relationship. And I think that the document's pretty clear about that, and I think that's the way that the industry handles that on a general basis anyway. There shouldn't be a lot of conflict between a project work order and the master subcontract agreement.
And I think we had one question that was concerned about the conflicts between the prime agreement and the subcontract, and what's the default there. And that would probably go to the same answer as most of the consensus docs 750 and 751, where, I mean, I guess I would say that if there is a direct conflict, the subcontract governs. In our federal subcontract, we actually have the prime agreement governs because we're dealing with federal work there. And if that is not that is the standard, but like what was mentioned before, if that is not what you're negotiated in your project, that is something that you would switch and modify, since the documents can be modified. So let's see here. This isn't so much a question, it's more of a comment, but let me see if I can get to this. Was about a comment here on the additional insured form. Let's see if I can get to it. Let's see if I can.
Regarding the blanket form, Brian?
Yes, yes, correct.
Okay.
I am looking for it. I read it and I thought I wanted to mention it to you guys. Oh, here we go. Just a note about the CGL additional insured form 2033-04-13. This has direct contract language included, making it not effective for blanket additional insured status covering multiple parties. I wouldn't recommend it. Somewhat of a comment, but do you have any reactions to that?
Yeah, I will start with the proviso that I am not an insurance expert by any means, but there has been case law, for example, in New York, dealing with blanket additional insured endorsements, and in short, the situation that arose was because of the particular language in that additional insured blanket endorsement, it required that the named insured, which was the subcontractor, have a contract with the additional insured, which is fine for covering the contractor, but it didn't take care of the requirement for the sub to name the owner and the architect and others as additional insureds. So you had a situation where, despite there being a blanket additional insured endorsement, it didn't provide that protection, and that in effect put the sub in breach of its subcontract agreement with the GC, but also put the GC in breach of its contract with the owner because it hadn't fulfilled that requirement to the owner. So you need to work with your insurance professional, particularly when you're talking about the use of blanket additional insured endorsements, which can be a wonderful tool, but there is a flip side there. I don't know if and how the insurance industry has responded to that particular issue. It really was a case that came down to the use of a single word with, and how that was interpreted. But please work with your insurance people to make sure that what you are providing, and obviously a project-specific or scheduled additional insured endorsement where the AIs are specifically named, is ideal. Make sure that you're giving what you're required to give and getting what you're required to get.
Yeah, and I would just add that you have the additional insured endorsement, the automatic additional insured endorsement as your backup, but it is best practices, and what we do is on each individual project to make sure that you receive an insurance certificate with attached endorsements, and if you need those in your jurisdiction to be scheduled, then make sure that you have a schedule of additional insureds rather than just, you don't want to just be an insurance certificate holder. So it is best practices that you do get a insurance certificate, and I would say that it's pretty easy in Sage 300 or whatever individual accounting program, project management program you use, to make it a condition precedent to the first payment that an insurance certificate be uploaded, and that's what we do, and I would assume that's what most general contractors do themselves, and it is best practices.
I have a question from Rebecca, who asks, the subcontract doesn't seem to cover design professionals like architects and engineers. Does Consensus Docs have a services agreement to cover these type of subcontractors? And the answer is, I'll take this one. The answer is yes. We have several design professional agreements. We don't have a master services agreement, and that would be a great suggestion under advisement to create another version using this type of approach. We also anticipate creating a master purchase order and a master prime level agreement, but we need to work on those on our working groups and would love to have you sign up. But we do the services agreements are the 240 is our design professional agreement. The short form version is the 245. And then we have a sub-consultant agreement, which is the 250. And then we also have a design build version of that, the 420 for design professional agreements. I'm going to take one more question, and then I'm going to ask the speakers for final thoughts. This question is kind of a bread and butter one in the sense that it's about liquidated damages. How do you handle LDs, and does it limit it to the proportionate share of the contract? And which contract would that be in? I would actually also ask you guys.
Well, the 755 under 5.5 deals with liquidated damages. 5.5.1 is the actual provision, and simply if the subcontract documents, which obviously includes the prime agreement, provides for LDs or other damages for delay, then such damages are assessed, then the constructor may assess a share of the damages against the sub in proportion to its share of responsibility for the damages, but it can't exceed any amount that was assessed against the constructor itself. So it's essentially a flow down provision that if it's in the prime, they are assessed and you are responsible or have a share of responsibility, a share of those LDs can be assessed against the subcontractor. That's the approach we've taken in the 750 and now the 755. I often tell contractors they shouldn't be as afraid of liquidated damages as they sometimes are, because it can be a way of narrowing your damages and avoiding other more significant damages. But obviously you need to be aware of it, and frankly it further underscores the importance again of getting that prime contract and make sure you review it as a subcontractor in particular to know what those LDs are.
And I would emphasize on liquidated damages. I personally would take liquidated damages in every single contract, because at least it's something that I know what the liquidated damages are going to be. But I would emphasize whether you're a contractor or a subcontractor that you limit the imposition of liquidated damages to the obtaining of substantial completion. I would avoid at all costs liquidated damages based on failure to obtain final completion. Substantial completion, that's reasonable, but limit your liquidated damages provisions to the failure to obtain substantial completion.
Well, that's great. Well, there are some more questions, and here's what I'll promise to do is I will get with the speakers and work on them with them as well on some of these additional questions, and we'll send those out. We're going to have a follow-up. You see our contact information here. We do send out these mass emails, so they should get through your spam filter, but if they don't, feel free to contact me directly or Joe or Kevin in a way of keeping in touch. With that, before thanking the speakers, would you guys have any last thoughts that you want to share with the audience before we sign off?
Joe?
No, I just thank you for your time, and if you are interested in these subcontracts, I would just encourage you to look at this Master Subcontract Agreement format. It is very helpful, and it is not that hard to implement.
I guess it would have been helpful if you created one for your company. Too bad you went first. You didn't have the standard to work from. But thank you for guiding us. Kevin, any last thoughts?
Same thing. I would just want to thank everybody, and I guess just picking up on what Joe said. I mean, we do recognize you may be on the other side of a master subcontract agreement. Somebody's presenting to you. It's regrettably not the consensus docs form that they're working off of, but you should feel free to go back and look at the 755 and when you're negotiating a master with somebody else, and try to incorporate what I think are fair and balanced provisions that are found in the 755 to make the the master agreement that you do negotiate a better agreement for you and for the other party. And beyond that, I just want to thank everybody for taking the time to listen in today and pose your questions. And we're here to follow up, as Brian indicated.
Well, thank you both, Joe, Kevin. Great job. Thank you so much for your leadership and insights on the working group and providing a great presentation today. Thank you, everyone, for taking time from your valuable day. We don't take it for granted. We will send you, and if you don't get it again, you can follow up with me directly. We will send you an actual recording, the PDF of the slides. If you didn't, we did send the samples out, but heck, maybe a couple of people didn't get those through, and so we could resend those too. Or you can always get a free sample by registering on the Consensus Docs website, and then you can get 3 automatically, and if you need more, you can just contact us. We have lots of resources on the website, and we will be posting additional resources for the Master Subcontract as well as other documents. Just go on our website under news and resources and such, and you can pick or get more tools for that. So have a wonderful rest of the day. Thank you so much, and I look forward to seeing you in person or hearing from you at a future virtual meeting and a webinar. Thanks so much, and have a great day.